Well, hello, Stuart. How are you doing?
Good, almost afternoon.
Yeah, not quite. Well, it's afternoon somewhere. And I'm sure there's some people watching us since we get viewers from all over the world where it's probably evening and afternoon and morning. Producer Eric, how you doing?
I'm doing good. Yeah, we're
Good.
kind of off our like normal time slot, but I got my half calf Nespresso. I'm ready to go. Let's just have a nice, calm, just chill discussion here on a Friday.
You warned me that I was supposed to be calm and chill today, so I'm going to do my best, Eric.
Yeah, well, we'll see what happens. We'll just see about that.
Eric, you had some comments you wanted to say.
Yeah, there's a few good ones that I think maybe you guys could use as points as you go along, and you kind of go down a certain avenue, and just maybe think about these a little bit closer, maybe as you're talking. So this is from JAG. They say, kind of in reply to our headline, isn't the situation more accurately that Justin is potentially in an unfair position rather than Blake, though? The way she and her lawyers have acted seems to have maybe put her at an unfair advantage. That's a fair, discussion point. So we'll think about that. I like this one here from, Ludwig. Could you talk about how can Justin prove malice without relying on any communications made by Lively herself? That's a good question.
That's a great question, Ludwig.
I think we can get to.
Yeah.
This is more of a comment, but I just, at least want your thoughts. Kind of similar to the first one. Lucas says, it seems more like the process is being super extra fair to Lively while JB is having his hands tied. Would love for you guys to kind of opine on that. But
right.
You can jump into it.
Well, I'll tell you one thing. There's a lot of people who want to be friends of this court.
I mean, out of the woodwork.
Yeah.
And they're just filing brief after brief. And wasn't Colonel Kurtz supposed to be filing a
She's
brief?
working on it. Yeah, I watched a video with her and Zach, and she said that she, and this is the thing, is that filing those briefs, it's a lot of work. We file briefs all the time, but by the time you put together the case law and you research it, I mean, it's no small undertaking. And I think she's seeing that it's a lot of work, and she's knuckling it down and doing it, apparently.
It'll be interesting, first of all, because everybody so far has been more on the Lively side of things. Yeah. At least from a policy standpoint.
Right.
And so Colonel Kurtz, if she gets hers on, somehow gets it filed, I'm interested to read it, and we'll do a show on it.
Yeah.
I'm interested to see what her position is and how she's going to help edify the court with her understanding that could be, helpful to the court in its understanding.
Yeah, that would be interesting. And there was 2 more amicus briefs filed in the last couple of days, one by a child advocacy group and then one by a group of 19 different organizations?
12, I think.
12?
Yeah, I think 19 organizations altogether. And the interesting thing about the one we're going to cover just a bit today, Keith, is this is, these entities are all over the place. Some of them are from New York, some are from California, but they're all squarely behind I forget the name of this law. This law we have here in California is at 49.
7.1.
It's 47.1.
Right.
So 47.1 again is raising its head, and of course we're going to have to discuss that.
What impact do you think all these briefs will have on the judge? That's a great question from JT.
We were talking about that earlier because, my initial thought was the judge probably won't allow this. They're coming late. And then you start getting more and more, and everybody's focusing on kind of the same policy. And it made me wonder, because quite frankly, I guess if I put myself in a position of the judge, I might get to the point where I'm like, yeah, you know what? I am going to allow these. There's a lot of people who want to speak on this issue and they have policy concerns. And so I'm going to go ahead and allow them. But I would give, of course, Baldoni an opportunity to respond. I wouldn't just, admit them without having a briefing schedule. But I don't know. The other way the judge could look at it is, look, these motions are fully briefed. Let's not waste the time.
Yeah, and if he gives Baldoni a chance to respond, then does that mean he has to give Lively another chance to respond?
Probably, yeah. I mean, everybody has to have a fair opportunity to come in and say their piece.
Just kind of feel like a federal judge isn't going to do that. I feel like a federal judge is just going to make a decision, and maybe he accepts the briefs and doesn't read them, the amicus briefs. Maybe he accepts them and reads them, but I have a feeling he knows what he wants to do in this case.
It's because
I'm just guessing.
Because it's been too long.
I think he's ready. I think they're getting close to making decisions.
And why are they all coming in now? I mean, we did look at the rule where, there's not a set rule in federal district court, but in theory, it should have been filed close in time to when the motion to dismiss was filed by Lively. So
yeah, I thought you made a good point that Brian Friedman, he's sitting out there thinking we're waiting for the judge's decision, and then you get basically thrown off by this and going, hey, wait a minute, why are they getting to come in here at last minute? primacy versus recency and those kinds of things. And so, does this get the judge who maybe is on the fence on one of these issues? Does the judge, say, "Wow, these briefs really do a good job"?
It really could. I mean, it really could. I mean, that's the problem with it. But I guess, the other way, the judge could just say, "No, I'm going to deny all the amicus brief. We're not going to have any amicus at this stage, and I'm just going to give my ruling."
Yeah.
Yeah, I can see it going like one way or the other, where it's like, oh, now we got to give JB's side.
That's the problem.
And people hate when we give like sports references. I'm sorry, but it's like they changed the overtime rule. So it's like, all right, someone scores, and now you get to have at least a chance to get the ball.
Yeah.
Right.
So,
Yeah, that's a good point. All right, so let's just take a quick look at this amicus, and Keith, just a couple of things I want to point out, and then I think we wanted to go to the complaint. But here are these individuals or entities. You've got the Sanctuary for Families, National Organization for Women, National Organization for Women New York City, Women's Justice Now, New York Cyber Abuse Task Force, Her University Inc., Women's Equal Justice, New York City Alliance Against Sexual Assault, Coalition Against Trafficking in Women, National Network to End Domestic Violence, Esperanza United, New York State Anti-Trafficking Coalition, Her Justice, and Urban Resource Institute. And they're all in support of defendant Blake Lively. And I just want to briefly, for those who have come late, for all the pros out there that already know about 47.1, we've been talking about it for some time, Keith. In fact, you started talking about it in early January, I think it was early January. But I just wanted to kind of bring us up to speed here. And, the retaliatory defamation lawsuit that was filed by the Wayfair parties. Now, keep in mind, retaliatory, it's a strong word, right?
Yeah.
It just means
sounds bad.
It's a responsive defamation lawsuit because there had to be a sexual harassment lawsuit, and then somebody had to get upset about that and file a defamation claim based upon that sexual harassment lawsuit.
It's a term of art. It just means that the lawsuit was filed after the first lawsuit.
So the retaliatory defamation lawsuit filed by the Wayfair parties against Blake Lively is another example of DARVO, which is deny, attack, reverse victim, and offender, in the post-Me Too era, where perpetrators of sexual violence, in particular sexual harassment, attempt to silence their victims into submission. Perpetrators use defamation suits to deny their own liability, discredit survivors of sexual violence, and reverse the narrative to cast themselves as the real victims. This smear tactic comes at a real cost to the victims, who muster the enormous courage required to report their abusers in the first instance. The use of DARVO tactics in defamation lawsuits is allowed to continue, if it's allowed to continue unchecked, embroiling victims in costly and drawn-out litigation proceedings that force them to relive their trauma and will embolden perpetrators and contribute to a culture of silence. This will impact survivors of all socioeconomic backgrounds, including those with the least means to defend themselves, as well as the most high-powered celebrities. And Keith, I just want to briefly touch on the quick nutshell they give on the California 47.1. And I'll be quick on this, and then let's move into the complaint.
This is the nutshell of the statute.
It is. So I don't know if they got this right. It says in 2019. I think it's 2023, but it could have been 2019. California amended its civil code to expressly provide protections for individuals who make communications about sexual violence without malice. Specifically, the law as amended provides that a communication that is made by an individual without malice regarding an incident of sexual harassment is privileged, and that's California Civil Code 47.1a. The law specifically applies to any individual who has or at any time had a reasonable basis to file a complaint of sexual harassment, where the complaint is or was filed or not. So whether or not the complaint is filed. And communication applies to a variety of forms of sexual violence, which includes sexual harassment. One last thing to add, and that's the damages, and that's what gets everybody focused in on this case, is the law not only protects victims' ability to speak out about their experience, but also provides the attorney's fees that shall be awarded to the prevailing victims in any defamation case brought against them for making a privileged communication for successfully defending themselves in a litigation, plus treble damages for any harm caused by them by the defamation action against them. So that's 47.1 in a nutshell.
Yeah.
And this is someone saying, and you guys were just saying this off mic, so broad.
So
That's
broad.
kind of the problem.
That's exactly right.
It is broad. And then Keith, the issue here comes down to a communication.
Right.
And so you wanted to talk about the First Amendment complaint that Baldoni had filed with his defamation claim against who?
Well, again, the defamation claim is against a lot of people, but we're focusing in on the claim against Lively. And let's see. So you can see right here, the second cause of action for defamation. This is out of Baldoni's First Amendment complaint. And it's against Lively, Reynolds, Sloan, Vision, and New York Times. So, but forget about all those other parties for right now, because we're really just focused on Lively, because she's the only one who has 47.1 protection. Ryan Reynolds does not. None of those other people have 47.1 protection. And so this is where they're saying that the Lively parties made one or more statements to persons other than the Wayfarer parties, including without limitations the New York Times, to the effect that the Wayfarer parties engaged in, permitted, or failed to prevent sexually inappropriate conduct towards Lively. So this is the problem. This is why 47.1 is being triggered. Let's see, and others, and that the Wayfarer parties retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Again, the whole that paragraph starts off by saying we're suing Lively because she communicated about an incident of sexual harassment. This is where 47.1 gets implicated. And this is where, the comment that you put up, Eric, about how 47.1 is so broad is so true. And that's why this is a problem for Baldoni's defamation claim against Lively. So now this is another paragraph where it says the statements made by Lively were intended to and did have the effect of exposing the Wayfarer parties to hatred, contempt, etc. Specifically, the persons to whom the Lively parties made the statements reasonably understood the statements to mean that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others. So again, this is a communication about sexual harassment. And that's why the law is just so broad. Any communication about sexual harassment. And one of the things that has been pointed out in these amicus briefs, and it's pointed out in the one that you were showing too on page 17, is that the whole purpose of 47.1 is to dissuade litigation against those who have made the difficult decision to come forward about their experiences. Now, you can say that you don't believe this person about her experiences, but the law is intended to protect anybody who's coming forward and discussing incidents of sexual harassment, whether they file a complaint or not. That's where it really gets crazy broad with this law.
So Keith, on page 17 of the amicus brief by these multiple entities, as you just stated, they say the amendment was intended to dissuade litigation against those who have made the difficult decision to come forward about their experiences and dissuade a perpetrator who would otherwise opt to silence survivors by targeting them with litigation due to the significant potential damages and penalties provided by this bill.
Yeah, now go to page 18. There's in the first paragraph on page 18, and they make a point, and this is really where the crux of this whole 47.1 is coming from. You see 3 lines down there. It says the plaintiff perpetrators filed the lawsuits not because they expect to win. Indeed, winning is not the point in most cases, but to use the cost and emotional toll of the lawsuit to bully the defendant victim into silence and to retaliate for speaking out against the plaintiff and intimidate others who might speak out, thereby chilling additional legitimate speech. So that's the whole premise upon which 47.1 was introduced to the California legislature and ultimately passed, is because they're concerned that people have been using defamation lawsuits to harm victims who come forward with sexual harassment claims. And I thought maybe we should, and I don't know if now's the right time, but let's just talk a little bit about what are the financial consequences of being sued for defamation.
Okay.
So if you're being sued for defamation, the first thing you have to do is hire a lawyer. How are you going to hire a lawyer? Are you going to get one on contingency, or are you going to have to pay them hourly?
More than likely, you'll have to pay them hourly because there's no win to be made.
And what kind of cost would that be to hire an attorney hourly?
So to get somebody of the quality of the lawyers in this case, it would easily be $1,500 to $2,000 an hour. If you don't have that kind of money, you probably could find somebody on the lower end of, let's call it $800 to $1,500 an hour.
Okay. And then once you engage in this lawsuit, what's the single most expensive kind of phase of the lawsuit?
Other than the trial, it'll be the discovery process.
And why is that?
Well, because it's usually many months of fighting over written documents that are laborious for both sides to deal with. So that just propounding the discovery and responding to the discovery is hours and hours and hours of work at $800 an hour, $900 an hour, whatever it is. It's very expensive. And then, of course, once you send discovery responses to the other side, assuming you even get to there, you might even be filing motions to quash, as we're seeing in this case. In fact, we saw that there was a motion to quash we'll get to in a few minutes on Stephanie Jones's matter. But then you get to meet and confers, and then you get to motions to compel, and then you finally get to depositions. And by that time, you're easily $250,000 to $500,000 in attorney's fees.
$250,000 to $500,000 just to defend yourself against defamation.
Yeah, and that's going light. I mean, you could be up to $1 million if depending on the case. Like here in this case, both sides I think are easily burning $1 million a month or more in attorney's fees.
They're in the millions, right?
In the millions, okay.
And then before you go to trial, your case probably is going to go to mediation where you try to settle. And what's going to happen to somebody who is a defendant in a defamation lawsuit when they've spent $250,000 and they're sitting at mediation? I mean, what's going to happen to that person when they try to settle that case?
Well, 80% of people wouldn't even be able to hire the lawyer. Okay, they're not going to be able to pay the $800 an hour for the lawyer. So they're essentially done. They're not going to bring their case forward. And there's that chilling effect because other people will see, hey, I saw what Keith had to go through when he tried to get a lawyer to stand up to the boss that was sexually harassing him. And he just ultimately got fired, couldn't do anything about it. And so I'm just going to keep my mouth shut. And yeah, the boss touches me and I feel a little funny, but I need a paycheck and I need to pay for food and groceries and so forth. So I'm just not going to get involved in it. That's the real answer. But let's just assume somehow, some way, somebody's got a lucky relative that's willing to throw in some money for them.
Right.
You're going to settle the case at mediation because it's just been so brutal to get there.
And you're probably going to settle for less than you otherwise would, or you just because you just want to get out of the case.
Yeah.
And then let's say it doesn't settle at mediation. How much is it going to cost by the time you hire expert witnesses and do everything you have to do to get ready for trial and then go through the trial?
I mean, let's just assume somebody that makes $100,000 a year at that type of a job, it's a white collar job. And they go through 3 years of litigation. I mean, it could easily be, $1 million, $1.5 million in attorney's fees.
I mean, that's a monumental cost for, the average person to have to incur that. And so it makes sense that 47.1 is being passed with the idea of we don't want people countersuing for defamation. Number one, just don't do it.
Right.
But number two, if you do, we want to give a release valve where the court can dismiss that before the discovery phase because it's so expensive.
That's correct.
So, I mean, I guess it makes some sense. The law makes some sense. Now let's apply it. Let's see how that applies.
Okay. Well, producer Eric, do you have some pictures you can put up for us?
Yeah. Let's go to our deck here.
I got a line of questions for Keith. So Keith, I want to introduce you to two hardworking, industrious people here. We got a woman and a man up there, and they're both working fast food restaurants. So they're probably making minimum wage. Don't have a savings account of much, I wouldn't imagine. If they didn't inherit any money from their family, they're working every single day and they're paying their bills and they're just getting by. Does 47.1 in your mind, the way that it's currently written, first of all, does it apply to these two individuals if they file sexual harassment claim and there's a defamation claim filed in response to them in retaliation to their sexual harassment claim?
Or if they even communicate about a sexual harassment incident and then they're sued for defamation. So yeah, 47.1 would apply and it should apply. I mean, these are the type of people that would not have the means to try to defend themselves against a defamation countersuit.
Okay, and I'm interested in what the jury pool feels about this. Should a person making minimum wage who really doesn't have the ability to hire a lawyer on an hourly basis, should 47.1 apply to them? And I'm only asking you the should because I think it does apply to them. We can all agree, or at least I hope we can all agree, the law is on the books and it does apply to them. But should it apply to them? And I don't want to get into was there malice or not malice because we're going to talk about that in a few minutes.
Yeah.
But I just want to say, should this individual be protected by 47? Should these individuals be protected by 47.1? I'm going to vote that not only are they protected, but they should be protected. I like the law for these people.
Yes.
Okay.
And so, yeah, we're going to talk about the malice. And I know it's hard, but like you're trying to say like, hey, and it's tough, but forget about these two parties here, Baldoni Lively. This is why it was set up. These are probably cases, you don't see these cases in the news like you do.
Right.
There could be, a lot of these going on.
Right.
So
Yeah,
I understand your point.
Again, these two individuals here, they get sued for defamation. We want to make sure that they have something to fight back with against the person that just wants to bury them.
Yeah.
And remember, these anti-SLAPP statutes came out of developers, right? Big time developers would sue a mom and pop store, or they would sue like somebody that owns a house that they wanted to somehow, get eminent domain over in some way for their project. And the little person, which maybe they'd saved their whole life for $100,000 to live on in retirement.
They get sued into oblivion.
They would get sued into oblivion, and they would have to, basically give up the case, and they'd lose all the money. And so now anti-SLAPP statutes came along. So 47.1 is just an anti-SLAPP statute that's on steroids.
Right.
Okay. All right. Let's go to the next picture. Okay. So now we don't have people that are at minimum wage. We have blue collar workers here. And let's say that they're making $100,000 each at their jobs, Keith, and some big boss man,
the CEO
comes in and sexually harasses one or both of these individuals. Does 47.1 apply to either one of these individuals?
Yes, it does. And it should.
And it should. So no argument from you that, these people should be protected by this law.
Right.
Okay. And the reason we want to protect the fast food workers and the blue collar workers is because of the disproportionate relationship between the person that sexually harassed them and who they are from a monetary standpoint, right?
Yeah, that's the problem. And so they couldn't possibly, pay $500,000 to $1 million to defend themselves in a defamation lawsuit. It's impossible.
So the big bad boss man that's doing the sexual harassment, let's just assume they've got a lot of money.
They can afford to do it.
They can hire 2 or 3 sets of lawyers to bury this person, right?
Yeah. I mean, if you have $10 million and you have to spend $500,000 on attorney's fees for a case, and just because you want to prove a point or have some principle, you can do that. When you make $100,000 a year, you cannot spend $500,000 even over 3 years to defend yourself in a lawsuit. It's just not going to work.
All right, Eric, what's our next profession? Oh, Keith, a lawyer, the best profession. Okay, so we have this young lawyer in her 20s, probably there, late 20s, maybe early 30s. She's associate. She's going to be up for partner. She's making, let's call it $250,000 to $300,000 a year with bonus. It's good money. That's more than 95% of the population. So she's making a lot of money. And one of the main 30-year partners at the firm is sexually harassing her. And, but she's not like the McDonald's restaurant worker. She's not a blue collar worker. She is a highly paid individual. Should 47.1, well, not should, but in your opinion, does 47.1 apply to her?
It does. Yeah. And still, I think it should.
Even though she makes that much money?
Yeah. But a law firm, a big partner at a big law firm, they make way more than that. And it's still a disadvantage. And again, it comes back to what's the policy reason here. And if the policy reason is to put a stop to countersuits by defamation, then it still has to apply here. In this instance.
So again, I'm seeing that there's a relationship between the perpetrator and the victim. The perpetrator is more powerful and can bury the victim. And so we as a society who elect our representatives have decided that we want to protect this young lady. And even though she's a highly paid employee and she has resources, we still want to protect her from the abuse that somebody that's much more powerful than she is could impose on her.
We do. We want that, number one. And number two, we want to make sure that nobody else gets a chilling effect, because if this person here decides that she can't sue, then how does the paralegal who works for the same firm feel? Or how does the legal secretary or the person who works in the copy room feel? They're going to see what happens to this person, and that's going to guide their conduct as well.
Okay. Who's our next person? All right. So, Keith, we have a neurosurgeon. That's my neurosurgeon there. We have a neurosurgeon, and she's probably making, let's call it $800,000 a year. Now, she's got a lot of student loans, and that's going to take a long time to pay back. But she's making $800,000 a year. She's making way more than that lawyer, which I take offense to, but that'll be for another day. So she's making $800,000 a year, and she's, let's call it, in her 3rd or 4th or 5th year as a doctor, and as a physician. And there's another neurosurgeon that's been working at the hospital for 30 years, and he comes up behind her at surgery and does all kinds of things that are causing a hostile work environment, and sexual harassment rise to that level. This person that makes $800,000 a year, she's in the top 1% of earners, does 47.1 apply to her?
It still does.
And should it?
It should.
Why? She makes so much money.
I know. Now you're getting into the level where, well, maybe she could spend the money or afford to defend herself from a defamation countersuit. But I still think that there's a secondary policy that's just as important that the legislature has expressed, which is it puts a chilling effect on the people around her. And so if she's not able to be protected by 47.1, then how does the nurse feel? How does the physician's assistant feel? How does the hospital administrator feel? People who make a lot less money than the neurosurgeon, but potentially could be harassed.
Well, what if the neurosurgeon here with 30 years, he's worth $20 million. He could bury this neurosurgeon because she's still paying off student loans and everything. What if he comes forward and says, yeah, but she's lying. And she has unethical attorneys. Her attorneys are so unethical. Let me tell you, these are some of the most unethical attorneys I've ever seen. And she's a bald-faced liar. Should 47.1 still apply to her?
So I'm having a hard time trying to think of a situation where a lawsuit can get past 47.1. Now, it's true that it's a qualified immunity and privilege, which means if somebody makes a statement with malice, it doesn't apply to them. The problem is, and this happens in all anti-SLAPP suits. So when there's a countersuit of any kind that's subject to an anti-SLAPP motion, there has to be a factual showing that you have a reasonable likelihood of succeeding on the merits. It's not good enough to make conclusions. And so you can't just say, well, she's lying, or at the time she said this, she knew it to be false. Those are just conclusions. And so factually speaking, what do you need to show malice at this early stage? And it is a little, we had a question we fielded yesterday or the day before about, doesn't this do away with due process for the person who has been, allegedly defamed? And to some extent, it does. It definitely curtails the due process period that they get. But on the other hand, it's outweighed by this policy. So what do you need to show that there was any malice? I mean, I think you would have to have a pretty severe case. You either would have to have some communication from this neurosurgeon where she told somebody, I know this is false, but I'm going to say it anyway because I hate this guy and I'm going to destroy him.
Right.
Or you'd have to have some sort of very clear evidence that, well, she never even worked in that hospital. I was never in that operating room.
Never met this person in my life.
And I have, all this hospital staff who will say, we've never met this doctor. We don't know who she is. She's never been around here.
Right.
I think you're going to have some factual showing. I don't think it's enough to simply say she's lying, or when she said it, she knew it to be false. It's just not going to be enough.
Okay. So even though go ahead, Aaron.
I was just going to say, so Keith, those communications, can you just make that crystal clear for me? Those are factual statement if there are communications like you just mentioned?
Well, communication, what I'm saying is in order to get your lawsuit past 47.1 at the motion to dismiss stage, you have to show some facts of malice. And so the communication wouldn't be a communication about sexual harassment. It'd be a communication where maybe, this doctor emailed or texted somebody else and said, I know that what I'm saying is false, but I'm going to say it anyway because I want to destroy this guy.
Right.
Right. Okay.
And something else to keep in mind here, the factual part of this, a lot of people are saying those are determinations for the jury to make. And I agreed with that on 47.1 initially, that whether she was reasonable in making the report and thought she was truthful, and as long as there wasn't malice, those would be determinations that a jury would make. But I think I was wrong on that, because the legislative history here of this statute is the legislature wants the courts to make this determination prior to the discovery phase. And if that means prior to the discovery phase, that means a judge is going to make this decision, just like they do on anti-SLAPP decisions. It's
a harsh rule. There's no doubt about it. And I guess the question, and by the way, my statement of there's some text where this doctor said, I know this isn't true, but I'm going to say it anyway. 99.9% of the time, you're not going to have evidence like that. Nobody says that. Even when it's true or they're thinking it, they don't send a text message that you get a hold of. But I'm just trying to think, what type of factual showing can you bring in to get past a dismiss?
Look, this law was designed to keep people from filing defamation claims.
They just don't want it.
And we as a society are saying there's going to be some uncomfortable moments for a few people in this, and we're willing to accept that because this is not a perfect, no law is perfect.
Yeah.
There's always going to be unintended consequences, but we see that there's just a plethora of women that are being abused in the workplace, and we want to protect them. And we want to protect them because the people that are hurting them are so much more powerful than they are. And so much like a developer that's, coming after a mom and pop store and is going to bankrupt them, they don't even care. The developer doesn't even care if they win the lawsuit. They just want to bankrupt the other party. That's what's going on here. And I think, again, this neurosurgeon who is earning $800,000 a year, it's more money than, God. And yet she still, in my mind, should be protected by the statute because there's somebody more powerful than her that wants to bankrupt her for bringing forward claims. And then, like you said, the chilling effect as you go higher up the ladder is bigger and bigger because there's all these other women below that, and in some minority cases, men, that are seeing, well, if she can't bring her claim and she can't be protected, why would I ever bring my claim?
Yeah. I mean, I think the law really doesn't want defamation cases to survive in this context. I think you're right. But it's an interesting situation.
All right, let's look at our next slide, Eric. Oh my gosh, that's Megyn Kelly, who sued Roger Ailes of Fox News for sexual harassment and won $1 gazillion. Oh my God, her lawyer was Brian Friedman.
Yeah.
I mean, this is all coming together for me now. If Megyn Kelly filed for sexual harassment against Roger Ailes, a very powerful man who was worth $100 million or more, and again, she was not worth $100 million, and if 47.1 had been on the books, which it was not at that time, and Roger Ailes had filed a defamation claim against Megyn Kelly, would Brian Friedman have raised 47.1 to protect his client, Megyn Kelly?
Oh, of course. Any lawyer would.
So Ezra Hudson's doing that. Brian Friedman's doing that. Any lawyer that could protect a client with 47.1 is going to use it, correct?
Absolutely.
And here, Megyn Kelly, she's famous. She's beautiful. She's well paid. I don't know if she's just well paid. I don't know how much she got when she was at Fox News. It may not be what a neurosurgeon was making, or it may be more. I don't know, but I know she was paid very handsomely. Should she be protected by 47.1 had it been around when she filed her sexual harassment suit?
Yeah, I think it would protect her if it was a California-based suit and she had a communication about sexual harassment, and I think it should.
And it should, because again, Roger Ailes, 80 years, I think he died at 77, but he's in his 70s. He's worth a lot, and he's got a corporation behind him, and he could crush her. He could crush her just without even caring if he wins or not. He can crush her, and the legislature saying, we don't want that. We want Megyn Kelly to come forward, the Megyn Kellys of the world, and we don't want them to fear being crushed in a lawsuit.
So really what we're saying is that we're okay with the few unfair results because of this law, because on the whole, on a broader issue, this is an important protection, and we want this protection for the people in, I guess, the state of California.
Correct. What's the next slide? And I think it's going to be one of her contemporaries. This is Gretchen Carlson. This is how we found out about the Megyn Kelly lawsuit. Gretchen Carlson was also at Fox News, also sexually harassed by Roger Ailes.
He's a busy guy.
He put her into bad time slots, and she came and talked to him about that. And allegedly, he said to her, "Well, you should have had sex with me, and I wouldn't have put you in those bad time slots." Which
that's not appropriate.
Which you do, I guess. Okay.
No.
And I didn't mean you personally.
Yeah.
So Gretchen Carlson, again, I think she's the same analysis as Megyn Kelly. That even though she's famous, even though famous in the journalistic world, she's well paid and compensated. 47.1, if it was around when she had filed her sexual harassment lawsuit, goes there. All right, we got one more slide. Oh boy.
Get this lady off the screen.
Trying to remember who this is. I've seen this lady before.
Yeah.
All right, so we've got Blake Lively here. Okay, now Keith, famous, married to a very wealthy man.
Yeah.
She's wealthy too. She is claiming sexual harassment. There's a defamation claim made against her in response to that. Does 47.1 apply to her?
And let's make it extreme. So let's say that Baldoni is the only party on the other side. So let's take away Wayfair. Let's take away Sorowitz. Let's say it's only Baldoni.
Okay.
But he's still sued for defamation, countersuit. So does 47.1 apply?
Yes.
Even though he certainly doesn't have the money or the resources that Lively and Ryan Reynolds has.
Right.
And the answer is yes, it does. And then the question becomes, should it?
Yes.
I mean, I think it should.
Yes. And why?
Because it's the same policy. The policy decision hasn't changed, which is it has to apply to anybody who has a communication of sexual harassment. And there is a chilling effect that happens if somebody who is higher up and has the resources isn't protected, what do people who are lower down think? They think, well, if that person's not protected, then how am I going to be protected? So it is difficult when that happens. Are you coming on the screen?
No.
It's difficult. And again, this goes back to the thing that I said before, is that there's going to be some cases where you're going to look at it and you're going to say, wait a minute, I don't think this is a fair application of the law in this particular instance. But that reminds me of the analogy I made, was it yesterday or the day before, when we were talking, I said it's kind of like beyond a reasonable doubt for criminal charges. If we use the standard of beyond a reasonable doubt to convict somebody of criminal charges, undoubtedly there's going to be some people who are guilty of crimes who are going to get off. That's not a fair result, right? But we still have that standard. Why? Because protecting innocence is so important to us that we're willing to let some people off, even though they're guilty of crimes, because we want that standard to help promote and protect innocence. And so that's really what's happening here, is you have a policy that the state has said is so important that we just don't want people countersuing for defamation. But if you do, there's going to be a big hammer hanging over your head.
So here's a question too, and we had talked about this, but how can Justin crush Blake? And you talked about, you know the answer to this with Sarowitz and the money backing him.
Well, that's it. Is that Justin has a good point. Thank you.
And that was Alexandra. So
you've got a billion. Thank you, Alexandra. You got a billionaire who allegedly said that he's going to spend $100 million on this case, and I'm assuming more if he needed to. And so again, it's that whole relationship between the victim and the perpetrator, alleged perpetrator, of course, and alleged victim. Is the victim, even though it's Blake Lively, she's less powerful than the Wayfair parties, because not only of Steve Sarowitz, but Wayfair itself, which he's part of. And collectively, there's a group of them. So she's less powerful than they are. But even if she isn't less powerful, I think your point's well taken. The law should still apply to her. It should still apply because that's what we want as a society.
Well, and there is no carve out that says that this law applies unless, you've been in, 3 movies that make over 500 million in domestic and, worldwide gross. I mean, there's no exception like that. It wouldn't make any sense. It has to, almost any law would have to apply across the board or not at all. Otherwise, it's not going to work. And so it makes sense that has to apply. There are 3 ways that Justin Baldoni can go on the defense, though.
Okay.
So number 1, he can just defend the sexual harassment claims,
which we've said all along.
Case 1 and case 2, right? Mm-hmm. So case 1, the sexual harassment claims, he can just defend against that all day long. That's one way. Number 2, because he has a billionaire backing him up, he can sue for defamation anyway and see if he can get it past the motion to dismiss. And if he does, fantastic. Now, if it ends up that he somehow loses the defamation claim and he owes a bunch of money, well, he's got a billionaire backing him up. They can just pay it. The third way he can go on the offensive is with some of his other claims, which we haven't talked about this yet. We've talked about it here and there, but we haven't done a video on it specifically. And he is suing Blake Lively for things like breach of contract because she violated the terms of the contract or the covenant of good faith and fair dealing. So it's not as if he doesn't have means to go on the offensive here, but the defamation claim against Lively, it's always been the problem. And we've pointed that out for a long time. And, it's just, that's the way the law is made.
Yeah. Yep.
While we're still on this, I think this is a good discussion, at least. Mar, this is an insightful comment. Can an income selection criteria for 47.1 law be established to help prioritize who need legal assistance and filter out frivolous cases?
And that's the point we were trying to get at with all of our photos.
Right.
Is you have a neurosurgeon that's making $800,000 a year. I mean, are we going to say that 47.1 only applies to people that make $100,000 a year or less? And does that mean if I am a perpetrator of sexual harassment, I only sexually harass high income women, so that I can't, I can then bury them if they decide to sue me, because I can sue them for defamation. So I don't know how that works. I mean, can you do a means test on a statute like this, Keith?
I mean, I suppose anything's possible. The only statutes I can think, there are means tests sometimes for you can get a waiver of filing fees with the court if you don't make enough money. The most obvious place where the amount of money you make varies
policy
is tax policy. But I think it'd be difficult. I think it'd be problematic to try to say 47.1 only applies to people who make this much, because ultimately you're going to have a situation where it should apply and it doesn't. I'm not saying it's impossible, but it'd be tricky. It kind of reminds me of, like if you have a murder statute and you say, but it's not murder if the person who's murdered is not a useful member of society. And then it's only like manslaughter or
So
something.
if I killed a homeless person, I should only go to jail for 10 years.
Yeah, because they don't make that much money and they're not that productive.
But if I killed you,
then you should
a round of applause, standing round of applause.
Then you should be hung by your thumbs until dead.
Ouch.
But it becomes problematic. I mean, there's some laws that simply have to apply to everybody or they apply to nobody.
There was something else in that question, though. I don't know if you can recall it back up. It has to do with how do you keep frivolous lawsuits from happening?
Yeah.
And I think it's important we talk about this just for a minute. How do we know it's frivolous?
Right.
When do you know a lawsuit's frivolous?
Usually when it goes to trial and the jury makes a decision.
Okay. And so before then, and you see, there's a lot of content creators out there that are saying things like, Blake Lively is evil and Blake Lively should, she's losing her case and she's, lost all of her friends and her family and her teeth and whatever else. I mean, it's, on and on and on. You're not going to know about frivolous lawsuits until, hopefully they go away through the discovery process and you'll never hear about them in many cases. But a truly frivolous lawsuit that goes all the way to trial, I just don't think it's going to win in front of a jury. But juries make the determination of whether something is frivolous or not. Juries get to hear evidence. Judges are there to make sure that the proper evidence is brought in, not just any willy-nilly evidence. I mean, if you pulled up some of the content creators here and put them in front of the jury would, oh my gosh, this is a horrible person, but the jury's not going to hear all that. They're going to hear evidence that the court believes they should hear so that they can come to a proper determination in the case.
What about this? What if you had a law where, either you could sue for defamation or you're not blowing the statute. You somehow can put the claim there, but you don't get to litigate it until the sexual harassment claims go to trial. And then as part of the trial for the sexual harassment claims, there's a jury instruction about, do you think this was with malice? Mm-hmm. And so the jury then makes a determination. And then based on that, the defamation suit either goes away or it's allowed to move forward after the sexual harassment claims. I mean, I guess the problem with that is the legislature literally does not want people filing defamation claims at all.
Right.
But the upside is maybe it'd be a better protection to allow people to at least try the sexual harassment claims. Now, 90% of cases settle before trial. So the case would probably settle and the defamation would go away with it. But at least would be a different way to go about it. And maybe it better protects people from these situations. I don't know.
Yeah. How many lawsuits have you tried yourself that you knew were meritless?
That I like my side was meritless?
Yeah.
Oh, none.
And how many cases do you take on at the firm that you believe are meritless?
None.
And I think the truly, I don't know what you want to call it, smash and grab lawsuit. Those do happen, unfortunately, but they don't make it long, in my opinion. And we certainly, our law firm chooses not to do those. And I know a lot of other law firms that choose not to do them. So, the idea that, the personal injury bar is going to be taking frivolous cases, I just don't see it happening.
Well, it's at least another approach. It's just a thought that came off the top of my head, but you're right. I mean, we would never file any lawsuit that doesn't have some basis in law or fact. And so if it didn't have at least some basis in that, why would you file it?
So I feel like I've seen a few comments, and it's a fair point. People are saying this incentivizes false claims. And what about, think about it the other way. If you see these people lose in court or have to settle, why would you make false claims if you know you're probably not going to win? And this was a comment from Fiona, which says, of course, talking about all the people we showed, of course, we want to protect those workers, but that doesn't stop me from wanting to protect people who have false accusations made against them. And yeah, I feel like that's where the problem is. And we see, I think I can speak for all of us, is we watch all these Blake Lively interviews and she's very abrasive. We don't like her. And the public keeps seeing these things and it just makes you want to hate her more, which I totally get. It would almost be better if that's not the way it works, but these two parties were like faceless, because you keep seeing, Lively mistreating our friends like Shasti Flaw. And it's like, wow, I really want to hate her even more.
It is funny though, the law applies to everybody, even jerks and a-holes.
Yeah.
So, I don't know how you get around that.
This might be odd, but like, what if there were false accusations, made against YouTube, for an example, and like, how would you want the judge to address 47.1? This is a tough question, I know, but
Well, I mean, it's easy to talk about when and it's not currently happening.
Yeah.
Obviously, I'd be very upset if somebody, Eric, if you, made sexual harassment claims against Keith and I'd be very upset about it. I don't know if I'd want to hurt you because I like you, but let's assume that I do want to hurt you. But I want to bury you for how dare you say this to me? Because Keith and I know about 47.1, we'd say, is there any other way we can get Eric? It's not going to be 47.1 because, that the legislature has spoken. It says, don't do that. But what if we had some type of a contract with you? Well, now we're in a position where, maybe you breached that contract. So now we can make you go through the paces for a breach of contract, which Justin Baldoni does have in this case. He's able to bring a breach of contract, breach of covenant of good faith and fair dealing. He's still going to be able to put Blake Lively through the paces. It just won't be for defamation. So that would be how I'd look. But to be honest, it's not comfortable when you're sued for sexual harassment, especially if you don't believe you did it.
right.
But that's why you defend yourself. And I think there's still people that have the idea that Justin Baldoni is somehow not able to defend himself because of 47.1. And that is not true. He is fully able to defend himself from the claims of sexual harassment.
Well, and the question was, how do you protect against false claims? You defend yourself. You go to trial and you win, and you show that it was a false claim and that there was no sexual harassment. And I, as the defendant, prevail. And therefore, I have that jury award saying that the defense wins. That's how you fight against false claims.
Mark Spence just asked a good question. Is there a statute of limitations on 47.1? And Keith, I think that's a good thing to talk about. 47.1 does not create a statute of limitations. The cause of action is a statute of limitations. And so for personal injury, Keith, what's the statute of limitations here in California?
2 years.
Okay. So Mark, in answer to your question, the statute of limitations to bring a claim for personal injury would be 2 years. Although keep in mind here with this particular type of claim, there's the FEHA requirements. And I know they just recently changed the statutes. I used to do a lot of FEHA defense, believe it or not, when I first started practicing way back in the day, 2004. And I worked with a really neat partner that taught me how to do demurs. Anyway, where was I headed with that? Do you have any idea where I was headed with that?
You said that
About the
the statutes
statute.
were changed a little bit from that time.
So you have to keep in mind there's a timeline for FEHA too, but I
Yeah.
think it's much more generous now than it used to be. It used to be a year for FEHA,
Yeah.
even though the underlying claim for personal injury was 2 years.
Right.
Here's another example too. I like these live examples. It helps me at least. Does that mean I could go to the press with a false claim about sexual assault by Ryan Reynolds and he can't sue me?
Well, it depends on where you do it, Jag. I would be careful. I would make sure that I was in California. And then if you make a claim, make sure that it does not have malice in it. And it sounds like to me that you're just saying, can I just go out there and, willy-nilly make this claim? I would never recommend somebody to do that. But if Ryan Reynolds did actually sexually assault you, then you would have to figure out what state you're in and where the sexual assault took place and where the venue is, what causes of action you have available to you, what defenses he has, and also can he sue you? Those are all things you'd have to think about. In California, you would be much more protected under 47.1 than you would be, say, in Texas or Florida.
Let me change that example just a little bit. So let's say, because if you've never met Ryan Reynolds, you've never been around him, I think it's going to be kind of hard to get 47.1 protection. But let's say you did work with Ryan Reynolds and you worked together for 3 months on a project. And one time Ryan Reynolds came up to you and said, you look handsome. You're looking handsome today. And then that was it. And let's say that you then later go to the press and you say, I was sexually harassed by Ryan Reynolds. And he said all sorts of horrible things to me, including commenting on my looks. Would you be protected by 47.1?
Yes.
But that's really not sexual harassment. What happened? How could you be protected?
Because you're saying that you had a belief that you were sexually harassed by Ryan Reynolds. And so as long as you truly believe that, you could bring that claim forward. I think you would end up losing that claim. And I think it would not make it in front of a jury. I think it would matriculate itself out by way of a small nuisance settlement or something. But if Ryan Reynolds was really upset about it, he may make you put that in front of a jury. And I don't think one incident, as we learned from our jury instructions the other day, one incident of somebody, hey, you look really nice today, that's not enough.
But is it enough to get 47.1 protection? Is it a communication regarding an incident of sexual harassment?
It could be. You don't think it is?
No, I think it would be.
Oh, okay. Yeah.
I think the statute is just that broad.
Yes.
Which is like, well, don't sue for defamation.
Right.
Or countersue.
What about this whole fact, like, I feel like we really get everyone speaking gets like in the weeds. And what about this incident? You know, it was in New Jersey and not California. So, I mean, I don't know what uh, the jurisdiction, like, where do we stand on that?
This is a venue issue. Keith, do you want to attack this one?
Sure. Yeah. Well, it all comes back to the fact that the Wayfair parties have argued that California law should apply to their defamation action. 47.1 is a privilege against defamation, as is 47, the litigation privilege. So if you're going to apply the law of defamation of California, then you're also going to be allowed to use all of the privileges that protect against defamation under California law as well. So that's really the issue. And the reason why Wayfair wanted California law is because California provided for more causes of action against the New York Times and against Lively, for that matter, that other laws don't. And so the choice of law in this case it's a complex issue, but basically that's why California law, I think, is going to apply, and the Wayfair parties have argued it should apply for defamation purposes.
Okay, thanks. Because I kind of forget that they're the ones who sort of brought it up for that causes of action thing. That's interesting. How about this question from Alexandra? How can JB get damages, loss of jobs, without suing for defamation? Also, thanks for everything. We know how busy you guys are.
Thank you, Alexandra. Well, the damages will come from other causes of action. So they're not going to come from the defamation. Well, they could come from the defamation in this case because he's actually brought it, but he's now facing the trifecta of damages as he moves forward, which is got to be not comfortable. So he could, if he wins, if he's the prevailing party in this case, then he will get damages of some sort, and she would not be the prevailing party, so she would not be able to get the additional damages against him.
And you're saying under some of the other causes of action, like the breach of covenant of good faith and fair dealing and those things. Yeah.
Yes.
If all he had was the defamation countersuit, though,
He would be in trouble.
and it gets knocked out by 47.1,
Yeah.
then the answer is he will not be able to get compensation for lost jobs.
And what do you think about my thoughts on that, Keith? I mean, it does seem like the legislative history is very clear on this point, that they want judges to make this decision prior to discovery really getting, full blown going. Now, obviously, we have discovery going on right now, and we're going to get to an order of the judge yesterday on discovery. But do you think that, this is a determination that for the judge is going to look at 47.1 and go, the legislature in California wants me, the judge, to make this decision?
Do I think the
Yeah.
judge is going to say that?
Yes, to himself.
I think there's a good chance. Yeah. I mean, I think that's the policy behind the law. I think the legislative history shows that. I think the judge is going to say, well, what factual showing have they given me to get past this 47.1 issue? And if he doesn't feel satisfied that it's there, then I think there's a good chance that he would dismiss it. I think there's a good chance he'll dismiss the defamation against New York Times too. Does it end up with a rather severe result when it comes to things like how is Justin Baldoni going to sue for loss of jobs? Yeah, it does. But there again, that's where the legislature has decided that's the policy we want. The best definition I ever heard of politics is that it's the authoritative allocation of values. And so laws, by their authority, allocate what values we're going to protect and what values we're not going to care about as much. And this is a perfect example of that. This law is protecting a value of protecting victims, and it's doing it at the expense of sometimes some people not being treated fairly. But we're okay with that because the bigger goal is more important. So the legislature says, and I think it is.
All right.
Yeah, I feel like it's a greater good situation, which no
It's
one
a greater
loves.
good
Like, no one
situation,
loves a
yeah.
greater good thing because,
No.
some people, will be harmed. But I would like to see a study somehow if they could, it'd be tough to quantify, but like a false claim sort of study, like what percentage, like I said, I know it's hard to quantify, but.
The problem with sexual harassment claims, I feel like, is that they're just so polarizing. And you and I were talking about this before. You could be sued for breach of contract, and nobody's going to think poorly of you if you're a defendant in a breach of contract claim. They're going to be like, oh, there's some dispute over, some contract. Who cares? But if you're a defendant in a sexual harassment claim, it's like, you almost become a pariah just by virtue of the fact that you've been, there's allegations against you.
Right.
And that's the problem, I think, with the sexual harassment claims.
And one could say also the victims of sexual harassment, when they come forward, their careers are harmed as well. So
And historically, that's been true, and they've been attacked. So,
all right. So we want to, if you have more questions, that's fine, Eric. But first, we wanted to jump real quickly, Keith, into Judge Lyman making a quick order here, and let's take a look at what was going on here.
yeah, this was kind of interesting. This shows you how kind of federal judges don't mess around.
So Jones Work LLC and Stephanie Jones, they moved for a protective order prohibiting the Wayfair parties from enforcing a subpoena on them that was served on Edgeworth Security Services LLC, and the court grants the motion. Jones Work hired Edgeworth in mid-2024 in connection with obtaining legal advice and preparing for potential litigation. And Jones Works argued that the documents sought by Justin Baldoni's subpoena or Wayfair subpoena, that documents are protected by the attorney-client privilege and attorney work product doctrine. Interestingly, the Wayfair parties did not dispute that the documents that it wanted were protected by the attorney-client communications or attorney work product, but they did argue that the documents were therefore still producible under the crime fraud exception to the attorney-client privilege and attorney work product doctrine. In particular, the Wayfair parties assert that Edgeworth falsely imprisoned defendant Jennifer Abel and then improperly obtained her private communication and data. And if you'll remember, Jennifer Abel was put into a conference room where her
security guard outside,
security guard standing between she and the door, and she was asked very pointed questions, and she was out of her element clearly, as anyone would be under those circumstances. So the judge granted the motion on behalf of Blake Lively's team
and stopped the subpoena.
Jones LLC and Jones Work LLC and Stephanie Jones. So what was the reasoning by the judge?
Well, first, let me just set the context a little bit, because this is a subpoena that was issued by the Baldoni team against Edgeworth. Edgeworth is not a law firm. It's a security company, and I probably is the company that extracted data from the phone, is my guess.
But they also gave legal advice, apparently.
Well, I think that they were doing it in preparation of their case with their lawyers.
Correct.
So in other words, the lawyers went to them as a vendor. Now, we as lawyers, when we hire vendors to help us with our cases,
attorney-client privilege work product.
Yeah, because they're agents of what we're doing, and therefore it's covered under the attorney-client privilege.
Right.
And so the Wayfair party said, well, but we want the documents. Even though they're covered under attorney-client privilege, we still want the documents. And because we think that it falls under what is called the crime and fraud exception to attorney-client privilege. That exception is where an attorney helps a client commit a fraud. So if a client comes into our office and says, hey, I want to defraud my company, can you help me figure out how to do it? And we sit down and we formulate some plan. All of those communications where we're engaging in this crime or this fraud are not protected by attorney-client privilege. So that's what Wayfair was arguing. The judge didn't buy it. The judge said, no, I don't see the crime or fraud exception, because I didn't see any facts that you pointed to that would show that these people were somehow involved in some crime or fraud in terms of what they were doing. You're saying that there was a false imprisonment, but that in and of itself doesn't answer the question of, yeah, but that an attorney office can still go out to a vendor and extract data off of a phone. That doesn't have anything to do with any claims you've made for false imprisonment or anything else.
Right.
Just that communication is protected by attorney-client privilege. And Judge Lyman said, I don't really see an exception that is stated here based on the facts. Was that your understanding?
That was my understanding as well. Yep. So not a huge ruling, but it's certainly something in the discovery phase, and there's going to be no production from this entity, whether they were a vendor or actually providing legal service or legal advice of some sort. Those documents are protected by attorney-client privilege or the work product doctrine.
And apparently it was the communications with Edgewater. Now, that doesn't mean that the underlying text couldn't be produced. So if there was text on the phone, or messages were sent from Jennifer Abel's phone over to Leslie Sloan,
yep,
the underlying evidence can still be had. It's just not the communications with Edgewater.
Yep.
All right. Here's a question. Why do you use a title? Why is the title of today's podcast what it is? Why Blake Lively deserves fair process? Yes, even now. And I'm the one who made that title, so maybe you guys can't speak for me, but
what were you thinking, Eric?
That was the idea. Yeah.
Well, Cindy, what I was thinking is that there's so many content creators out there that are just bashing Blake Lively daily, talking about how horrible she is, what an awful person she is, and how she's losing her case and losing her friends, and everything is very bombastic, and everything is, a 5-alarm fire. And I would like to see Blake Lively get the same fairness and treatment that Justin Baldoni gets, and that is they have a right to take their claims to court. We certainly can take a position, whether we want to be on Justin Baldoni's team, that's fine. If we want to be on Blake Lively's team, that's fine. But if we could be a little bit more respectful, we can't mandate this, obviously, but this is just my thoughts. I mean, we have content creators that are taking lawyers' heads and putting them on the bodies of snakes. We have other content creators calling Ezra Hudson a snake in the grass. Everything that Ezra Hudson does in this case is unethical. Everything that the lawyers for Blake Lively do is unethical. Everything that about Blake Lively is unethical. We once went over some of the logical fallacies. And if you find that you're just making personal attacks, if a small group of people are just continually making personal attacks against somebody, you may have to check yourself, because it would be nice if you could get into the facts and the law and discuss those. And it's okay to be transparent about your bias, who you like better, who you don't like. But the bombastic nature of what's happening to Blake Lively, I feel bad for Blake Lively. I think she is a good person, and I think that Ryan Reynolds is a good person. Are they flawed? Yes, just like all of us. We're all flawed. We're all flawed human beings. There's times where we have good days and bad days. There's days where we take advantage of our position in life. Keith, how many times have we've been traveling somewhere and you're a lawyer and some person tries to, whoever tries to get a business person tries to tell you how things are going to be, you take offense to it and you maybe say things that you shouldn't say, and you take advantage of that situation because you have superior knowledge over that person. It happens. These people are all hurting. Justin Baldoni is hurting. Even Sarowitz is hurting, I believe. Nobody likes this litigation. I think they all want it over. It's just trying to find a path to resolve it. It's so hard right now because of the heat and the excitement and the bombastic nature of what's happening. But it does bother me that I feel like Blake Lively's not getting the same fair shake that Justin Baldoni is. And that's all I would want for all litigants. When we talk to a jury and we ask them in voir dire, we say, hey, you're going to be sitting on this jury, and one of the things we want to know is, are you going to be fair? And what that means is, are you going to be fair to them, the defense, if we're for the plaintiff, and are you also going to be fair to us? But are we starting at the same starting blocks? Are you more defense minded, so you're giving them a little advantage, or are you more me advantaged and you're going to hold them back? We don't want that either. We want you to give us both a fair shake to win this trial.
Yeah,
and I do think the evidence here is quite strong for Justin Baldoni from what we've seen.
Yeah.
Say that again a little bit louder for everyone.
I do.
I do too. Yeah.
And I really like Justin Baldoni. I mean, I never met him, never talked to him, but you've got content creators out there divining what is inside Blake Lively's head, telling us what she's thinking and how she's feeling about that, and why she's making, and why her lawyers are thinking and doing things. Somebody was explaining how Brian Friedman filed something in 2 days, but not 4 days or something. And I'm like, how would you even begin to know that? And you can't know that. And so the title today was the idea, can we all give each other a little bit of grace? Can I go on one more thing,
Sure.
Keith? And that is, my dad just recently passed away, and you guys have, and the jury pool's been great about it. And Eric and Keith and everybody here at the office has been great about it. But because he passed away, I just thought a lot about our talks, and he loved history. And he was born in 1942. Mm-hmm. And he tells me that one of his first memories he remembers is McCarthyism. And McCarthyism was the idea that, if you were accused by Joseph McCarthy of being a communist, your job was gone, your career was over, you were stained, you were blacklisted. And because everybody was so afraid about the Cold War, and communism was a big dirty word, and it was the worst thing you could call somebody. And I remember, there's this hearing, and I don't know, it was there 1954 or 1955. There's a hearing, and there's a lawyer at the hearing, and his name is Joseph, but I can't remember his last name. And he's representing the U.S. Army. Yeah. And there's somebody that McCarthy is just, calling a communist again, and just blasting into at these Senate hearings. And McCarthy is a senator, and he only lived to 48. He was a chronic alcoholic, died of cirrhosis of the liver. But here he is, just blasting these people for being communist again, because he's been so effective in doing that. And, it's bombastic. It's over the top. It's three lawyers' heads on a snake body. It's just ridiculous. It's some point, it's like, what are we talking about here? And this lawyer, his words are famous. We don't remember his name. His words are famous. And he says, sir, what does he says?
Have you no decency?
Have you no decency, sir? Have you no decency, sir? And, it really shut down McCarthy. I mean, he kept talking, but you could see it just cut him off. And I would ask the same thing of all of us, me, you, the jury pool, everybody here. Are we decent enough to give this case, everybody, a fair shot in this case, no matter how we might feel about them? And can we also bring the temperature down just a little bit on everything Blake Lively and her lawyers do is somehow evil and unethical and horrible and, the worst thing ever. And maybe think that maybe they're just making some missteps over there that are embarrassing, no doubt.
Yeah.
Maybe they don't have as strong of a claim as Justin Baldoni. That's fine. We can talk about that. Those are things we can get into. But when you're calling people out personally and saying that they should be disbarred, and it just bothers me. So I would hope, if I could convey to anybody, can we give everybody, including Justin Baldoni, let's give everybody a free chance to go to a jury. Let the jury determine this case. And the judge is a good judge. He's going to make sure the jury gets the right evidence to make that determination. And I think we're going to get a good outcome from the jury. And after that, then you can say, aha, victory if you're the winning side, and you can also say, I knew it all along if you want to. But until then, let's quit attacking people on a personal level, especially for things like ethics and, if they're evil or not. That does bother me. I went on a long time to apologize for that, Keith.
That's okay. I mean, I do care about the fairness of the process. I also care about talking about these issues. So when we're talking about 47.1, I don't think it helps to point out all the reasons why it's a horrible law, it's unconstitutional. I mean, maybe it is. And if that's your view of it and you have a good articulation for why that is, but there's also a policy behind it that, maybe it's important. And there are times when all of these laws result in bad results in certain cases, and that's just the way the law works. But I at least want to have the ability and the freedom to raise the issues and discuss them and, not feel like, oh, you can't talk about this. Well, no, you can talk about it. In fact, we need to talk about it. We should talk about it. And that's what we're here to do. So, I mean, to me, that the title really was more of let's talk about this process and let's talk about it fairly. And how it should apply and the way it does apply. And then, like you said, ultimately it'll go to a jury and the jury will tell us, and it'll tell us who's right and who's wrong.
Yep.
Yeah, I like that too. And to agree and disagree with you at the same time, I don't really think Lively's a good person. I don't like Reynolds, but I still think that they do, deserve the shot at the trial. And yeah, like they might lose in the trial. So then everyone can be happy. Not everyone. Sorry, I shouldn't say that. But
can I put you on the spot, Eric?
Please.
So have you spent any time with Blake Lively?
No.
Have you spent any time with Ryan Reynolds?
No, sir.
Okay. So this is your perception of them from a public standpoint.
Yeah. But I have the right to.
Absolutely. You do.
Yeah.
I'm not saying you don't.
Yeah.
But you've never spent any personal time with these people.
That's correct.
And you've never spent any time with Ezra Hudson or Brian Friedman or.
Mm-hmm.
Okay.
Justin Baldoni.
Mm-hmm. Yeah. Okay, cool.
Is there anything else you wanted to go over?
I want to, maybe this wouldn't take too long, but people are shouting out this footnote on the response. I mean, you guys are big into footnotes.
Okay.
I do love me a good footnote.
Did he do it without prejudice?
Here, I'll monologue for a second too.
Oh, the order?
Here, let me pull it up, Keith. Okay, let me get over
Okay,
here.
you got it.
Let's see here.
Yeah, okay. So the Wayfair parties have provided evidence of an action filed in New York State Court by Van Zandt Inc., a corporation purportedly associated with Lively against those 1 through 10. The Wayfair parties assert, without providing evidence, that this action was filed solely in order to allow Van Zandt Inc. to subpoena Jones' work for Abel's communications under New York law. This does not provide probable cause to believe that the identified communications between Edgeworth and Jones or Jones' work were in furtherance of a crime or fraud. So they're saying that as far as the court's concerned, that in and of itself is not enough to make the fraud and crime exception to the attorney-client privilege. Now, I would not read this as being a ruling by the court on the Van Zandt situation or whether evidence is blocked. I think the court was just saying that this in and of itself is not enough to allow these communications between the lawyers and Edgeworth to be disclosed.
Well, and I think you and I have been saying for several weeks now that we don't have enough evidence to make a determination on the Van Zandt lawsuit. And I know that there are many people that strongly disagree on that, and they feel that they've been able to divine and understand everything that happened and who gave who what. But I think we do have to let the evidence play out, and that is, what did the lawyers know? What did Blake Lively know? What did Stephanie Jones know? Those are all things that are yet to be determined. And you can see the court is actually agreeing with us. I'm glad the person pointed us to footnote 3 here, because he says, look, the Wayfair parties have asserted without providing any evidence. And that's the key. You got to show evidence to show some type of bad act on the behalf of the lawyers involved here And that's why I think everybody jumped the gun. In my opinion, everybody jumped the gun and said, aha, look, there's another horrible thing that these unethical, horrible lawyers have done.
But we don't have the evidence yet.
No, it may turn out to be that they were unethical in how they
Yeah.
did this. We don't know, but let's let the process play out. Let's be fair about it.
So this is where, right now, probably Friedman's doing discovery, sending out subpoenas, trying to find, evidence to support this.
Well, and that also should help people that have already made up their minds. And I'd ask them to reconsider making up their minds that if Brian Friedman isn't moving out on something, that means he doesn't feel as strongly about it as you do. And he's the lawyer in the case that could really use something against Blake Lively. And so the fact that he has been silent for the most part on the Van Zandt issue, I mean, not silent, he's mentioning it, but he's not doing anything about it. Even he's looking at it going, I don't know what I have here. I might have something good. I might not have something good. We have to let it play out.
And he doesn't want to file anything until he has the evidence to back him up.
Why not? Why wouldn't he want to file something?
Because it'll be dismissed. I mean, you don't want to file something that you're going to lose and give the other side a false win.
Right.
So what you'd rather do is let's spend the time to do the discovery. Let's get the evidence to back us up. And then let's file our motion with evidence. And then the judge can't tell us that we're making claims without evidence. There'll actually be evidence to back us up. That's what we want.
Yep, absolutely.
Thank you guys.
Anything else? Are we good?
I think that might be a good stop.
We're at an hour and 11
Yeah,
minutes.
we went a little
It's
late.
long time.
Hey, I'm going to do a little housekeeping and then you guys can wrap it up.
Sure.
So
Okay.
I've seen people that all these episodes get uploaded to the podcast apps, Apple Podcasts, Spotify. So if you miss something, you can always listen in the car or listen on your commute. If you want to rate the show, that'd be awesome. We'd appreciate that. And yeah, that was all I want to do. Oh, we got, we don't like to hawk our own stuff too hard, but there's the jury pool mug behind you, Keith. There's the 12B6
Oh, yeah.
mugs behind. If people like that stuff, go for it. It's all linked there. Like I said, we don't talk about our merch too often, but hey,
It's there if you want it.
exactly.
Hey, Eric, I want to throw this one up. Alice Jones says, I hope Stewart
Oh,
gets accused
God.
of sexual harassment and has to go through all this kind of stuff and see his opinion changes. And Alice, my response to that is, I hope you are never attacked in any way, shape, or form that you need lawyers and have to go to court because it's a brutal process. And in addition to that, I hope you have a wonderful weekend.
Have a good weekend, Alice.
What else you got?
I made it almost all the way through, Eric.
Almost.
Eric's
yeah.
like,
Got so close.
Yeah.
Well,
Well, that's
anyway,
good.
it's Friday, so everybody have a good weekend, and I'm sure we'll be back with you next week.
all right, everybody
Right.
have a great weekend. We'll see you. We don't just talk about the law, we practice it. At Albertson and Davidson LLP, we're dedicated trust and probate litigation attorneys fighting for abused trust and will beneficiaries.
If you're facing a trust or estate dispute, visit aldablaw.com to see how we can help. And don't forget to join our jury pool by liking and subscribing. See you next time.